Welcome back, Excellencies, ladies and gentlemen. In our previous panel, we heard strong descriptions of some of the risks posed by AI to human rights, democracy, and the rule of law. And we also heard calls for comprehensive regulatory approaches to address those risks and mitigate them. As you know, the Council of Europe's Ad Hoc Committee on AI, CAHAI, mentioned several times in that discussion, has been exploring both the feasibility and the prospects for a binding international regulatory framework. Let us hear more now on the interim results of the committee's discussions. And I'll just remind everybody before I hand over that we do welcome your questions as well. You can pose them on the conference website using the code that you were sent by email. And our next speaker will happily answer your questions after his introductory remarks. And now joining us live from Slovenia is Gregor Strojin. He is chair of CAHAI and state secretary at Slovenia's Ministry of Justice. Welcome. The floor is yours.
Thank you, Melinda. Thank you also for the introduction. Just to make a correction, I'm no longer the state secretary at the Ministry of Justice. I'm the advisor of the President of the Supreme Court. But the name is Gregor Strojin, and I'm the chair of the Ad Hoc Committee on Artificial Intelligence at the Council of Europe. And I look forward to talking to you and the guests if there are any questions on the work of CAHAI. I will be using some slides, and hopefully the technician will be able to help me with that. So, as you know, CAHAI is an intergovernmental committee of the Council of Europe, which was established by the Committee of Ministers on September 11, 2019, with a mandate to examine the feasibility and potential elements of a legal framework for the design, development, and application of AI systems in line with Council of Europe standards on human rights, democracy, and the rule of law. So, we can distinguish two sets of deliverables that were requested from CAHAI by the Committee of Ministers. And these are to be delivered by the end of the 2-year mandate. This is by the end of 2021. The first deliverable is a feasibility study. The second are the potential elements of a legal framework. We started our work at the first plenary of CAHAI in November 2019, and by the beginning of 2020, we have optimistically set a roadmap which seemed ambitious but realistic. Then the pandemic struck. So for most of us, this was the only roadmap we got to use during the rest of the year. So we took advantage of the circumstances, moved our work into the virtual, and through extensive use of video conferences, email consultations, but most of all, with enormous motivation, commitment, and determination of the involved experts and members, finished the year as planned. At the third plenary in December 2020, feasibility study was adopted. And CAHAI is currently well on track and in the second half of its mandate. You will see on the slides, there is a scan code, QR scan code, that you could use to access the documents that I will be showing throughout this presentation. So feel free to use it and look more into the details of the document. In the preparatory phase during the first half of 2020, we examined risks and opportunities and mapped the existing binding and non-binding legal instruments in the international fora. Most of this preparatory work was published in a dedicated publication towards regulation of AI systems. This is also available on CAHAI website as it holds value on its own. And I would like to thank the Japanese government for helping us produce this document. Our work is based on a multi-stakeholder approach by design. CAHAI has a very broad and inclusive membership, and it is already composed of 47 member countries, 6 observer countries, and a number of other participants, such as various intergovernmental bodies and international organizations, representatives of the industry, NGOs, civil society, and academia, who all contribute to the ongoing process. Such complementary knowledge and input of various groups is essential to produce relevant and effective results and has benefited the quality of the feasibility study greatly. So, as part of our approach, we also took into account the numerous initiatives being considered or undertaken globally, in particular by the EU, OECD, UNESCO, and the United Nations, also in order to identify the already elaborated common values and principles, existing solutions and their elements, overlaps and gaps. We will, for example, also pay close attention to the work of new initiatives, such as GPAI and its results, as the quality of the gathered expertise and the assigned objectives can be of significant added value for our legal instruments. We are all faced with common challenges and should provide a coherent response. We must also consider the limited availability of crucial resources to do so, especially of experts and time. Each organization has its own mandate, but at the end of the day, our work should strive for complementarity if it is to be efficient. Adoption of the feasibility study at the December plenary took 3 days of intense discussions and negotiations. But this, however, was done on the shoulders of many months of prior work by the dedicated Policy Development Working Group, in short, PDG. 30 experts in the PDG, 19 from the member states and 11 from observers and participants, prepared the initial text from September to November. Their output was followed by a month of online consultations during which all delegations had a chance to submit comments, and they did so in large numbers. At all stages, emphasis was given to listening and taking into account opinions of different stakeholders. CAHAI Secretariat, working group co-chairs and experts continuously worked to adequately address and integrate all of the comments into the final coherent version of the document, or to allow them to be reflected otherwise. Active stakeholder collaboration required continuous attention to details in order to find the highest levels of consensus possible. As a recognition of their efforts, I need to especially mention the co-chairs, Mr. Wolfgang Teves from Germany and Mr. Zoltán Turbeck from Hungary, and Ms. Natalie Smucha, who served as an independent expert and who was with us today during the previous panel. And most importantly, I need to thank all the participants in the process, as they exhibited both differing positions on some aspects, as well as willingness to find compromises at the end and to formulate a final document which reflects this. So, what are the interim conclusions of CAHAI? Examination of AI impact on human rights, rule of law and democracy, and identification of underlining of gaps in the existing international binding and non-binding instruments clearly indicated that current legal safeguards are not sufficient. Legal protection has a number of substantive and procedural gaps. From a substantive point of view, the rights and obligations formulated in existing legal instruments tend to be articulated either too broadly or generally, and very often do not meet the specific challenges which are raised by AI systems. It is true, though, that we are not in a legal vacuum. Many international legal instruments, including Council of Europe treaties such as the European Convention on Human Rights, Convention 108 on data protection, or the Budapest Convention on Cybercrime are already applicable to AI systems. However, the number and diversity of instruments render it difficult to interpret and apply them to the AI context in a consistent and comprehensive manner, and this leads to uneven protection levels. There are also many procedural gaps, such as, for example, the necessity to ensure human control and oversight over AI applications, to ensure their technical robustness, and to secure effective transparency and explainability. These gaps, in turn, have an impact on substantive rights. Without transparency or explainability of an impactful AI-enabled decision, for example, it cannot be assessed whether a human right, such as, for example, a right to non-discrimination, is actually ensured. Legal gaps also lead to uncertainty for stakeholders, developers, designers, implementers. They lack a predictable and sound legal framework to design and implement AI systems. Uncertainty consequently risks hampering beneficial AI innovation. Gaps and fragmented approach of applying these instruments to the context of AI across Europe also raises uncertainty regarding tackling of the transboundary nature of impact, which is generated by the development and use, and a lack of common norms might hamper cross-border trade of AI products and services, leading to further fragmentation. We know that soft law or ethical frameworks cannot be the only answers. Indeed, They have provided guidance and have helped structure the debate about the fundamental principles that should guide the development of AI applications. However, their non-binding character and the lack of mechanisms for oversight of their actual implementation are major limitations for a pervasive and impactful technology such as AI. As was also shown during the debate, consensus is emerging, including within the private sector, on the need to go beyond ethics and to define a comprehensive legal framework. And we heard this also during the previous panel in this conference. So CAHAI proposed to address the gaps and challenges through a comprehensive legal framework combining binding and non-binding legal instruments that complement each other, and it has identified the main elements in its Chapter 7. Following a risk-based approach, a legal framework should provide an enabling regulatory setting in which beneficial innovation can flourish, all the while addressing the risks set out in Chapter 3 and the substantive and procedural legal gaps which were identified in Chapter 5. This is to ensure both its relevance and effectiveness amidst existing instruments. Key principles that must be secured in the context of AI and could potentially be considered for inclusion in the future legal instruments were described, and on that basis, concrete rights that individuals can invoke were identified, along with the requirements that developers and deployers of AI systems should meet. Among these, special attention was given to human dignity, prevention of harm to human rights, democracy and the rule of law, human freedom and autonomy, non-discrimination, gender equality, fairness and diversity, transparency and explainability, data protection and right to privacy, and accountability and responsibility. Just for an impression, I'm providing one example of how rights and obligations regarding one particular value were framed, the human dignity aspect. You are most welcome to take a look at all the other categories. And I would ask the technician to move to the next slide, please. Thank you. A binding instrument of horizontal character, a convention or a framework convention, could consolidate general common principles, while additional binding or non-binding sectoral instruments could address challenges which are brought by AI systems in specific sectors. Such a combination would also allow for legal certainty for AI stakeholders to be enhanced and to provide the required legal guidance to private actors wishing to undertake self-regulatory initiatives. Next slide, please. In 2021, CAHAI's work is moving into a new phase, next phase. A legal framework working group will prepare the main part of the second major deliverable and elaborate the specific elements of the needed legal instruments. The work will continue to be supported by the PDG. In the first half of 21, we will also strengthen and focus our consultation and outreach activities, as we would like to get feedback on the key elements of the feasibility study in order to prioritize and fine-tune our work appropriately for the conclusion of the mandate. So, as CAHAI moves forward, we need to remind ourselves that this is only one step on the path that society follows in the constant and continuous interaction and search for balance between technology and humanity, development and stability, innovation and regulation. And the longer we refrain from doing it, the greater becomes the risk of disruption with irreversible negative consequences, and smaller our ability to harness the innovation for beneficial goals. So thank you for your attention, and I welcome any questions that you might have.
Thank you very much, Gregor Strojin, and sorry about the wrong title there in my introduction of you. We do have a couple of questions that have come in from the audience, and since we don't have a whole lot of time, I'll ask if you would for fairly brief answers. And by the way, ladies and gentlemen, when you submit your questions, we would love to know who you are. So if you feel like including your name and/or organization, please do. So in fact, our first questioner did do so. She is Monika Remé from the National Council of German Women's Organizations, and she asks, how does CAHAI plan to prevent artificial intelligence systems from further exacerbating existing gender inequality?
Thank you. As a matter of fact, we are putting special attention to providing gender equality as a major part of our work. We also have a gender equality reporter, Ms. Jana Novogradska, who is contributing to the work we're doing. So we are paying special attention to this also during the work that we're doing. And we're also making this as an example of what the developers, designers, and implementers should put attention to when designing, developing, and implementing systems. So gender equality provides one issue of bias when we address the different data sets. It provides one issue of bias when it comes to who are the developers designing the systems? Do we put enough emphasis on the STEM resources for girls who are in the education process? In the long run, will we have a society where equality will be basis, and we will not just further some structural inequalities that existed in the past? So gender equality is an important part of both the narrow aspect of the preparation of the feasibility study, as of the output that we are trying to send to different stakeholders.
Thanks very much. Next question, again, with the request for a brief answer, if you would. I do have 2 more audience questions. Next one would be, what are the advantages of the CAHAI approach combining a horizontal framework with further sectoral rules?
Well, horizontal approach allows us to look at the general principles and how they could be applied for all types of AI applications. So how to provide general obligations to states in order to prevent violations of human rights, rule of law, and democracy, while sectoral approaches could look more into details for individual types of technology or fields of work. And we can see already at the Council of Europe that different bodies are working on aspects related, for example, elections, such as Venice Commission, or CEPEJ, the European Commission for the Efficiency of Justice, is looking how artificial intelligence could or should be used in some narrow aspects of justice, for example, for predictive justice. So we can look at the horizontal level at the overlying principles, principles that we can find in all types of AI applications, and we can also look at individual impacts on the vertical level at certain aspects. And if we look at both categories, then we can have a comprehensive output. If we just look at the general principles and horizontal, of course, we will be missing more than we should.
Thank you very much. And the last audience question I'll pose for now, maybe I'll take one more with me into the discussion that follows this one, but last audience question is a huge one, but I'm still going to ask you to answer it very briefly if you would. How long do you think it will take to develop and implement a convention on AI?
It is a difficult question. It is up to member states and their dynamics. We have heard a number of times during our meetings that we have examples of conventions regarding terrorism that were adopted in a matter of weeks or even just months. On the other hand, it can take years before we come to an adoption. And even after a convention might be adopted, it might take a lot of time before it's ratified by a sufficient number of member countries. What I'm hoping is that we at CAHAI provide a sound recommendation to the Committee of Ministers by the end of the year, and that our output will inform them on the way forward, and hopefully they will choose to authorize either CAHAI or some other committee to provide the next version of the document, which will actually be not just a feasibility study and elements of legal framework, but an actual legal instrument. So by the end of the year, hopefully we will have a recommendation and partially an answer to your question.
Thank you very much, Gregor Strojin, Chair of CAHAI, for taking us through what CAHAI has developed until now. We wish you the very best for your ongoing efforts, and we will take what you've told us into our next discussion. So thanks for being with us.
Thank you.